We are very happy to have you here joining this event. My name is Charlotte. I'm a student here at UPEACE in the Master of International Law and Human Rights, and I'll be moderating this webinar today. As you know, in February this year, the Russian army invaded Ukrainian territory. We heard a lot about this conflict in the news, but today you will receive a perspective from international law from our three professors of the International Law Department here at UPEACE. The University for Peace is a UN-mandated university that focuses on peace studies and adopts a holistic approach to international law and human rights as a peace-building project. I'll now give you the agenda of this webinar. It will be divided as follows. Our first panelist will be Dr. Juan Carlos Sanborgo, who is also the Dean of UPEACE. Our second panelist will be Dr. Maria Teresa Garrido, who is also our coordinator of the doctoral program of UPEACE. And our third panelist will be Dr. Mihi Kanaid, who is the academic coordinator of UPEACE and the head of the Department of International Law. He will give you his perspective as well as a presentation about the two master degree programs from the International Law Department here at UPEACE. After this, I'll share with you my experience as a student here. And finally, we'll have a Q&A session where you'll be able to ask us all questions in the chat. I'll now give the floor to our first panelist, Dr. Juan Carlos Sanborgo. The floor is yours. Thank you.
Hello, everyone. Merci beaucoup, Charlotte. Thank you, everyone. Well, first of all, it's a great idea that we can open this space to talk about what is the legal perspective of the situation currently in the conflict between Russia and Ukraine. Somebody wrote on one of our social media there was not a conflict, that there was an invasion, and we decide to use this technical word conflict because it's what that means. I mean, when you have a situation between two states and you can apply the legal framework that exists in international law for this kind of situations. I will share the screen, briefly present an overview of the mechanisms that have been activated within the United Nations and in general in international law in this situation. The United Nations is a key component, is the pivotal component of the mechanisms that activate around every conflict around the world. Everything started with a political approach, that is the United Nations. United Nations is a political body where the states debate the situations. I decided to present the situation with this like a circle, like a spiral, because in this situation, the United Nations was the first port of attention. Then the International Court of Justice start a case as a result of the situation that, of course, we will discuss it later on. The International Criminal Court started the case when the first conflict started. So when Russia annexed the territory of the area at the south of the country, then the Crimea Peninsula, sorry about that. Then the United Nations also activate something that some of authors have called quasi-jurisdictional mechanisms, that they look like legal, but they are not legal, and also what had been the stake of the regional mechanisms of human rights. So when we go to the political mechanisms, here we'll talk about what had happened at the Security Council. Was the first port of attention, the first port of action. But as a result of the structure of the veto power, the Security Council couldn't reach any decision. However, they did activate the mechanisms, they did operate it. It is very important to recall that when the invasion occurs, Russia was the president of the Security Council. And even though they were the president and the United States called for a meeting to discuss that topic, Russia followed the mechanisms, apply international law, and they held a meeting to discuss about that action. So it is very important. Also, I mean, as a result of the no decision of the Security Council, they activate a resolution for peace. There is a mechanism when the Security Council cannot reach a decision, and the topic was taken into the General Assembly, where they have a worldwide condemnation of the situation. That was very, very important. Also, an important message from the political point of view was the suspension of Russia from the United Nations Human Rights Council. It was a very strong message, very powerful about what is the stake of the international community on the topic. Also, I will not address that much, but it's important to keep in mind that the UN Charter has special provisions for regional approaches into conflicts. And in that sense, the European Union and NATO has played an extremely important role, especially on sanctions. I will visit the topic of sanctions briefly in this very short presentation. As I said, leaving aside the political mechanisms, this quasi-jurisdictional mechanism, why they call it quasi-jurisdictional mechanisms, why they call it quasi-jurisdictional mechanism, because they look like juridical, they look like a judicial mechanism. It's a body of inquiry where you have, body that recollect evidence and pronounce a decision. And even though that they look juridical, they are not. Basically, they report to the Human Rights Council, but is an important contribution to this conflict that the Human Rights Council established a commission of inquiry to collect all the evidence around this topic. And the two juridical mechanisms in place is the one at the International Court of Justice and the one at the International Criminal Court. As I said, in the case of the ICJ, Russia says that they were acting because on the region of Donbass, the Ukrainian authorities were committing genocide. Immediately, the Ukrainian government took the case into the ICJ, say, look, we have allegations that, that we are committing, the Ukrainians are committing genocide. That case was immediately admitted, and the Ukrainian government requests provisional measures that were basically a ceasefire. And the International Court of Justice, in the case called allegation of genocide under the Convention of the Prevention and Punishment of the Crime of Genocide, accept the provisional measures and also declare that what we have in the region was aggression. That is something really, really important to understand the flow of the case. On the other side, as I mentioned, in the International Criminal Court, we have a situation open when when Russia annexed the Crimean Peninsula, okay? But in this case, I mean, they have this investigation open since 2014, but as you are aware, that during this time, the prosecutor had changed. At that time was Madame Fatou Bensouda, now is Mr. Khan, and Mr. Khan is a bit more, I mean, it seems that he's more active than Madame Bensouda. And when the group of countries submit the request of investigation, the 1st of March, prosecutor can immediately do the case and reinforce the investigation. So it is very interesting, and I think it's a topic for us to study, the important changes on the role of the prosecutor in this case, because the prosecutor have announced, because when you see previous submissions, and this submission is an important change that I think is something that we need to review in the proper time. I will close this with this graphic that for me is very, very graphic. This is something very old because it's from March 9, but I haven't found a very clear view of the sanctions, the amount of sanctions imposed to Russia, not from the United Nations. It's basically regional approaches. That's why I mentioned the European Union, but also other countries like Australia or the United States. And then when you compare the scale of the sanctions imposed to Russia, they call it the mother of all sanctions now, because they are immense in comparison with any other conflict before. You see, Russia is in this moment that, as I said, it's March, that we are in May. So imagine how this has multiplied at least 3 times more. they have $5.5 billion in sanctions in comparison with the one approved to Iran, to Syria, to North Korea, Venezuela, Myanmar, and Cuba. So this is very interesting to see how the international system is trying to target the financial sanctions to avoid the confrontation, to avoid the use of force. However, these sanctions has proved not very successful in this case, but is also a topic very interesting for us at the University for Peace to analyze. So I would like to conclude that in this case, people normally attack international law. They say, no, it's not working, look what's going on, etc. Every time that we have the use of force, of course, it's a failure of international law and international system. We will not deny that. However, it is very important to see how the international organizations and the international community have been working to stop the use of force, to bring back the two parties into the table, and to impose as much as we have. If we have the menu of international law with us, I think we have applied almost everything that we have at the menu for international law for situations like this. I hope that I can give you an idea of this perspective, and I will be more than happy to exchange with you later on in the quick Q and answer section. Thank you very much.
Thank you, Dr. Juan Carlos, for this very complete and precise presentation. I've seen that there is another question, but we'll keep it for the Q&A session later. I'll now give the floor to Maria Teresa. The floor is yours. Thank you.
Thank you, Charlotte, and hello to everyone. I see in the participants some of our UPEACE students and some others that I don't know. So if you would like to chat with us and tell us from where are you connecting, it would be great. So I will be presenting a little bit on the idea of the use of ICTs and the right to freedom of expression in this conflict. So I will share my screen and I will guide you through that presentation. I will be I was talking about this for like 10 minutes, but I hope that it can bring a lot of food for thought for you, and then we can discuss it in the Q&A session. So, as you know, this is a new war in this century that is transforming our way of understanding conflict, because now we have information and communication technologies, and we have seen everything that is happening in real time is what we call the social media effect on the idea of communication studies. So I want to focus more on the idea of how we're going, how are we knowing more about this conflict, a little bit of the technologies that has been used by Ukraine specifically to demonstrate what is happening in the situation. So first of all, I want to just highlight the idea of the right to freedom of expression, because it's a right that almost all of us know, but I want to highlight certain parts. So Article 19.2 of the ICCPR, the International Covenant on Civil and Political Rights, indicates everyone shall have the right to freedom of expression. This right shall include freedom to seek, receive, and impart information and ideas of all kinds, regardless of frontiers, either orally in writing or in print, in the form of art, or through any other media of his choice. So here we see that in principle, we all have the right to seek, receive, and impart information about Ukraine and Russia and what is happening. And we saw this exercise of this right with the previous presentation, and we have seen this throughout social media. And when it talks about the idea of regardless of frontiers, it's like we all can do it, and through any other media is where we include the idea of information and communication technologies and how they are used in this conflict and how we are using it at this very moment. And I want to focus, because ICTs are almost everything that we are using nowadays, so I want to focus more on the idea of artificial intelligence. This is one of the first words where we are seeing the reality of the use of artificial intelligence in the recognitions of civilians, combatants, even in the mapping of the war, the conflict, the zones that has been affected by bombarding and all of the things that we have seen on social media and media in general. So for this, I want us to have like a clear, simple definition. This is coming from the Encyclopedia Britannica, and it's the ability of a digital computer or a computer-controlled robot to perform tasks commonly associated with intelligent beings. So this is what we basically say in general terms about artificial intelligence. Is just an ability that we are using this machine that is using algorithms, this machine learning to actually perform tasks that are usually performed by intelligent beings or human beings. And in this conflict, we have seen the use of face recognition in other ones, but I want to focus on the idea of facial recognition. This is a technology that has been in place for many, many years. This is not something new. And basically what it does is just take the picture of the person, highlights the characteristics of the face, and just identify it, compare that face, that data that is gathering, and analyze it in comparison with the database that already has the characteristics and the main features of that person. And as you can see in this picture, it adds the idea of the gender, the characteristics of the hairs, the person in general. Sometimes it can be linked to an identity number. It depends on the system and how it is working. But this is a special type of artificial intelligence because it's combining data with the use of algorithms and mixing them to actually do this type of recognition. So this is one of the main technologies that are have been used here in Ukraine and Russia. And I want to focus on the idea of Ukraine using this. So I want us to consider certain things. First is the availability of the infrastructure. When we are in a conflict situation, we all need information. We all need to know what is happening, like who are the combatants and how they are doing it. And in this war, we're seeing the use of mobile devices, internet, software, all of these infrastructure that allows to observe what is going on and monitor. So the idea of the availability of the infrastructure also talks about development existing in the country that allows to have this connection and exercise the right of the freedom of expression without borders and without these type of restrictions. The other thing that I consider important here in this conflict between Ukraine and Russia is the idea of the existence of a database of faces that can be used by the company Clearview. When the conflict started, this company Clearview is an American company offered the services to Ukraine, and they were saying that they were having all of the database based on the idea of social media used in Russia. So basically what they did was to took all of the pictures that were uploaded by the people in this social media and use it in the database for them. And now they are comparing the data. So it is important to know that for this to work, there is a previous work that this company specifically has been doing in the collection of this information that can be later compared. Another point that is important is the agreements between Ukraine and the company. And here we're seeing this development of international law and the private sector working with the state, and Ukraine, like the company Clearview, offer the help.
I think we cannot hear you anymore. I think you muted yourself.
Yes, no, somebody muted me. I got the signal, but thank you. Okay, so the idea of the agreements, like we're seeing this cooperation between the private sector and the state to perform these tasks that are very important for the idea of recognizing who is participating in the conflict. And then the next point is the use of traditional media to inform international community about this agreement. I don't know if you have followed this, but Ukraine decided just to make this public with the company Reuters, and they have the exclusive news about the use of Clearview. And I think this is extremely interesting in the way we are exercising the right to freedom of expression nowadays, because we can see the combination of traditional media that have a better understanding in this investigative journalism and the way they are presenting information about the use of these technologies, about the use of the developments in this sense that are important for us to understand the whole conflict. So these are kind of key points that we can see in this development of international law and the use of ICTs to exercise the right to freedom of expression. But as everything has a human rights impact, so I want to focus on the idea of the process. First, it helps with the idea of identification of combatants, and this is where Ukraine has had a lot of posts, and we can see a lot of news on how they are using this technology to identify soldiers who are detained or that are found dead. And this is an interesting progress in the idea of IHL, International Humanitarian Law. And then they are creating a database of combatants. They have this idea of we want to offer to the Russian population through information, and we want to help all of the people that are participating in the conflict from different perspectives. And another thing that we can see with refugees status and people fleeing the conflict is the idea of family reunification. They are scanning also faces, and they're using this database to combine it with the identification data and use this as a way of reuniting the families. But this is kind of one side of the coin, and I want to use the latest minutes that I have here for the cons. Because we can see here a breach of privacy. This company, Clearview, was collecting these pictures from Volkatanke. I'm sorry, I don't know how to pronounce it. I was speaking Russian, but this is the main social media where they were taking the pictures. And this is something that not only Clearview, but many other companies are doing. They're taking the data that is uploaded into the internet to create databases and then compare it. And this relates to the idea not only with the exercise of the right to freedom of expression, but also about privacy. And then we have a problem in terms of privacy and the exercise of freedom of expression in the idea of the lack of information about the use and storage of the information collected. We don't really know who is going to use this data after the conflict, how is it going to be used by any of the states, or what are the implications of the use of ICT. So I think the development of this war and this conflict and all of the situations that we're seeing in the use of ICTs can bring us a lot of questions on how it's going to impact our life in the near future. And then there is lack of information about further use of the technology by stakeholders. And there are many scholars discussing the idea of the private sector influencing the outcome of the war by providing ICTs in general. Is not only artificial intelligence, but drones and other forms of communication that we don't really know how it will impact the outcome of the war and how it will impact human rights, the exercise of human rights, because remember that this is a simultaneous exercise between IHL and human rights, and this is the point where we are nowadays. So I think from the perspective of the exercise of the right to freedom of expression, we can see this difference on how people are using ICTs in an innovative way that are producing different results that from the perspective of international human rights is very interesting for us to observe and watch. And with this, I will finish my part of the presentation, and I'm open to any questions that you can have later. So thank you.
Thank you, Maria Teresa, for this perspective from a freedom of expression perspective. I'll now give the floor to Dr. Kanade for your next intervention. Thank you.
Thank you very much, Charlotte, and hello, everyone. Welcome to all of you who are attending the presentation and the webinar today. My intervention will be slightly on a different point in terms of the role of international law in the Russia-Ukraine war and the Russian invasion, obviously, of Ukraine. I think one thing that we need to get off the table is the gross illegality of the Russian invasion. I think we all are very clear that the invasion is illegal in international law. We all have moral outrage over the conflict, but very briefly, I want to touch on the international law dimension of this illegality. with reference to the explicit statements made by Vladimir Putin in terms of justification of the war. Now, the first thing all of us must be aware of, and those of you who are in the program already and are attending, my students, you know that the United Nations Charter prohibits the use of force almost absolutely. There are only two exceptions provided for in the United Nations Charter with relation to the prohibition of the use of force. The first exception is if the Security Council of the United Nations under Chapter 7 of the Charter, which refers to the coercive measures that states can take, or the Security Council can authorize, if any such use of force has been done with such authorization, then that's okay, that's legal. Obviously, in this case, there was no such Security Council authorization to Russia to use force against Ukraine or its territory. So that exception is not applicable here at all. The second exception, which the United Nations Charter permits, and in fact has been invoked by the Russian Federation, is if force is used by a state against another state in individual or collective self-defense under Article 51 of the United Nations Charter. And therefore, this necessitates a closer examination of Article 51 of the United Nations Charter to understand whether the use of force by Russia could qualify as legitimate under the idea of collective self-defense. I think individual self-defense doesn't exist here because there was no armed attack by Ukraine against Russia. And the argument from Russia, therefore, was also not based on individual self-defense. It was based on collective self-defense. And how so? On 24th of February this year, when the Russian Federation decided to use force against Ukraine, President Putin went on air and justified that. And very interestingly, he used the argument that we are using force in collective self-defense of ethnic Russians in Donetsk and Luhansk, which are two regions, as you know, in the Donbas area in eastern Ukraine, under Article 51 of the United Nations Charter through a special mission. So he did not characterize the use of force as an armed attack or even a use of force. Somehow he characterized it as a special mission under the false assumption that this makes any difference to the actual characterization of the conflict. This is very important because in international law, it doesn't matter what you domestically through your own laws or policies characterize a particular use of force as. The legality or illegality of a use of force is always determined with reference to international law and not what you domestically characterize it as, right? So this is, there's an explicit provision on this in the, what is called the Articles on Responsibility of States for Internationally Wrongful Acts. So the argument here by President Putin was that Donetsk and Luhansk are self-declared independent regions. They are states by themselves. They are ethnic Russians in those areas. And Ukraine is using force against them. They're committing a genocide against these people. And they have asked us to come to their rescue by using force in collective self-defense under Article 51 of the United Nations Charter. So it's important for us to therefore closely examine the provision. And this is the ad verbatim reproduction of Article 51 of the UN Charter. Nothing in the present charter shall impair the inherent right of individual or collective self-defense if an armed attack occurs against a member of the United Nations until the Security Council has taken measures necessary to maintain international peace and security. Now, the right to collective self-defense, although it is inherent, which means that the UN Charter doesn't confer necessarily this right, it's already inherent in states, it's present in states. There are certain requirements for the right to collective self-defense to be correctly triggered. And one of them is if an armed attack occurs. In this case, obviously, there was no such circumstance where, or nothing on record where Ukraine's actions against the ethnic Russians in Donetsk and Luhansk could reach the threshold of an armed attack. Now, one qualification I should make here is that there is no doubt that there were atrocities, there were violations of human rights committed by both sides of the conflict since 2014. In fact, the United Nations Special Rapporteurs and the United Nations system has time and again since 2014 produced umpteen number of reports. And I was trying to recount them yesterday, and I stopped at some point because there's so many reports documenting violations by the armed forces of Ukraine as well as the rebel groups in these regions supported by Russia. So there were violations of human rights by both sides, including torture. However, none of that really reached the threshold of an armed attack for Russia to legitimately be in a position of using force that satisfies the requirements of Article 51. So there was no armed attack. Let's be very clear about this. So this argument of self-defense is fundamentally flawed, but more so because the armed attack requirement has to be against a member of the United Nations. Donetsk and Luhansk are not members of the United Nations. Their statehood is not recognized, and it's very doubtful that they are states in terms of international law. And there is no case that the armed attack had occurred against Russia, nor was it imminent against Russian Federation either. So the application of Article 51 is fundamentally flawed. There is no justification whatsoever for the invasion by Russia of Ukraine. And it doesn't matter what you qualify it as, whether as use of force or as a special mission. It is entirely irrelevant from the perspective of international law. Now, the second argument that Juan Carlos referred to was the genocide argument, that the Russian special mission was initiated by Vladimir Putin to prevent further genocide of ethnic Russians in Donetsk and Luhansk. Now, this argument is also fundamentally flawed because international law does not permit unilateral action through use of force, even to prevent genocide. Prevention of genocide is covered under a doctrine which was adopted by the United Nations General Assembly in 2005 called the Responsibility to Protect Doctrine. And under this doctrine, states are mandated to take collective action, both pacific and through use of force, whenever a particular country is failing manifestly to protect its own population from genocide, war crimes, or ethnic cleansing. And in such circumstances, of course, the international community must step in. However, what's important is that whenever the international community is required to use force, under the Responsibility to Protect Doctrine, even assuming that there was a genocide, it must always be done pursuant to a UN Security Council authorization. And that obviously was not present in this case. So even on these grounds, there's nothing to justify Russian action in Ukraine. Now, all of this has led many observers, and particularly those I would say both within the practitioners of international law community and those outside, to really question what is the value of international law, particularly the norm that prohibits the use of force when it is so brazenly flouted by Russia. What is the value of such international laws? Are they not merely window dressing? Right? And Juan Carlos presented a perspective on the role of international law and how important it is. And so let's look at some of the arguments in favor that international law is very important, its role is very much present, and also some of the critiques of international law. So the most important argument made by scholars and practitioners in favor of international law and its role, even in this conflict, is that, look, the value of law is a question that's distinct from the question of its enforceability, right? So a common example that's often given by international lawyers is one presented by Rosalind Higgins in her landmark book in 1994, International Law Problems and Process, where she says, look, all our countries have domestic laws that prohibit homicide, but homicides take place all the time. does this mean that the law that prohibits homicide is without any value, right? It's the same point that we have to borrow in terms of international law. The law prohibiting use of force is not useless because a powerful country decides to violate it. That act is simply a violation and needs to be treated as a breach. The problem in international law, of course, is that enforceability of a particular law is very weak, as we will discuss in the next couple of slides. But that doesn't necessarily entail that the law itself or the norm prohibiting use of force is without any value. Imagine a situation where there was no such norm, right? Countries would have unbridled right, unhinged right to invade another country whenever they want. And therefore, this norm does act as a constraining role. It plays a constraining role on state actions on many occasions. And this is testified by the fact that no country in history has ever said that its actions using force are a violation of international law. Even Russia, in this case, sought to justify its actions with reference to international law, trying to somehow, argue that its actions are justified because it's permitted as an exception under international law that prohibits use of force. So even the belligerent states, even those that violate international law, somehow use international law itself as a reference to justify their action. International law, even in this case, is clearly playing a key role in all stages of the conflict and will also continue to play a role in its aftermath. Particularly, whatever the result of the conflict is, there is bound to be a treaty at some stage involving maybe not just Ukraine and Russia, but perhaps a larger community in the region. And that agreement, a peace agreement, or whatever that is called as, would also be within the framework of international law. As Juan Carlos was pointing out, scholars also point out that, look, there are institutions, forums at the United Nations which have stepped in. The UN General Assembly has initiated an inquiry, an investigation into crimes. They've called for, sanctions. They have expelled Russia from the United Nations Human Rights Council. The UNHRC, the Human Rights Council itself, has initiated a procedure against Russian Federation of inquiry. The ICC, which is the International Criminal Court, has stepped in with an investigation. The International Court of Justice has been invoked. But what you don't find in this list is the Security Council, right? And that's really where the devil lies in the detail. And I'm going to come to that. But also, in addition, scholars point out that, look, international law permits certain countermeasures to be undertaken by states when a particular state is violating international law brazenly. And this is where the individual and collective sanctions have come in against Russian Federation. I'm in a webinar, please call back later. Sorry about that. So countermeasures take place. They are permitted by international law as individual and collective sanctions. And these can be both generalized as well as targeted. And that is exactly what has happened. Now, we have had sanctions against the Russian Federation as a whole. And these are all permitted under international law through the doctrine of what is called as countermeasures. And we've also had targeted sanctions against individuals from these various, from Russia, the oligarchs, those people that are close to President Putin, people, high-ranking officials in the Kremlin, and those that are closer to, again, the government. There have been targeted sanctions against this. Now, you see in the parenthesis, I have a word "but," and this is very important because the legality or effectiveness of countermeasures, particularly sanctions, has always been debated in international law. Now, as all of us know, President Biden suffers from what is called as a foot in the mouth disease, which means that he says things which slips out, and he shouldn't be saying those things, at least in terms of politics and international law. And in one of his statements, he did very clearly state that what we are trying to do is to make the imposed sanctions so that people in Russia, the common people in Russia, start rebelling against Putin and effect a regime change. Now, I'm not too sure whether making lives of common Russians who are even against the war, but have no say, making their lives miserable in order to effectuate a regime change is legally permitted under international law or through the doctrine of countermeasures. And that's where a huge debate lies in terms of international law. I'm more, in terms of sanctions. Personally, I'm more aligned with the idea of targeted sanctions against individuals who are responsible for making decisions, rather than blanket sanctions on an entire country, because ultimately the elites hardly ever suffer. It's the common person on the street who is against the war on most occasions that suffers the most. Now, what are the arguments against? And I'm going to be very brief on this because all of you are familiar with this argument. Most of the observers have literally critiqued the United Nations peace and security architecture during the conflict by pointing out that the Security Council has failed to discharge its primary mandate to maintain international peace and security. And as was pointed out, the primary reason for this is the very structure of the Security Council, which comprises the permanent 5 members, of which the Russian Federation is an important part. And as we know, the permanent 5 have time and again exercised veto powers, which essentially means that if one of the countries of the permanent 5 is using force against another, which is illegal in international law, or one of their allies is doing so, it is impossible for the Security Council to take measures that are effective, apart from discussing politically the issue. But what's also important is that this is not the first time where a permanent 5 member has imposed a veto power. And it's not just done by Russia all the time. It is very important to remember that there is a huge amount of hypocrisy in the outrage that we find against the Russian Federation today for its use of force, for its brazen invasion of Ukraine. In as much as that is absolutely illegal, and in as much as that should be rightly critiqued by one and all, we did not see this outrage when United States decided to invade Iraq or Afghanistan, which in case of Iraq also, that was absolutely illegal. More number of people died at this point in Iraq as they have in Ukraine, and the suffering. There's no point in kind of comparing the suffering of people. The point I'm making is that the outrage that we see today, although absolutely justified, does not sit well with the hypocrisy of the global North or the West. When it comes to their use of force and the veto powers that they have exercised in the Security Council earlier as well. And all of this is to point out that there is an original birth defect in the United Nations Charter and its architecture, which is the composition of the Security Council that confers the 5 permanent members such immense powers to grant, to use veto whenever a particular decision is against their interests. Now, I don't want to belabor this point, but this is a suggestion that I would like to leave you all with. There are many suggestions and proposals that have come in with relation to reforms of the United Nations Security Council. The countries like Germany, India, Japan, South Africa, Brazil, they've all been proposing expansion of the Security Council to 23 members, with them also gaining permanent status with a veto power. Now, I understand why their aspirations are present. And I have had many discussions and debates with academics and colleagues in India, where I come from. But my point is this, that although what I say is an unpopular opinion, but if 5 permanent members with veto powers have completely blockaded the Security Council, what makes us think that 10 permanent members with veto powers would do any better? right? So you're likely to have a bigger mess than what we already have. And so it's time really to think about rectifying the original birth defect of the United Nations, which is the structure of the Security Council, which completely flouts the principle of sovereign equality of states, because 5 countries are more powerful, more equal, so to speak, than others. And there are 2 provisions in the United Nations Charter which need to be invoked at this point. One of them is Article 108 of the Charter. This is about amendments to the United Nations Charter. The amendments to the United Nations Charter, unfortunately, are a non-starter in this context, because any amendments to the Charter and the structure of the Security Council require not just, they require adoption of such amendments by 2/3 of the members of the United Nations General Assembly, which is very easy to get. But that also requires all permanent 5 members of the Security Council to be on board, which means that any amendment to the UN Charter and modification of the structure, particularly the Security Council, would require consent of each of the permanent 5 members, and that's unlikely to happen. But what's very interesting is Article 109 of the Charter. And this is a forgotten article, and I think it is time that the United Nations system starts thinking seriously about this article. So what is this article about? This article required a general conference of the members of the UN for the purpose of reviewing the Charter to be held at a date and place to be fixed by 2/3 members plus any 9 members of the UN Security Council. So this is not subject to the veto power. Any 9 members of the Security Council, along with 2/3 members of the General Assembly, were required to initiate a general conference for review of the United Nations Charter. Then it says that if such conference is not held before the 10th annual session of the UNGA, which is long past gone, it shall be automatically placed on the agenda of the General Assembly, and a conference can be called if so decided by simple majority of the UNGA, which is 50% plus 1, and any 7 members of the UN Security Council. Now, this has never happened. This has never happened. So a review of the United Nations Charter through such a conference has never actually taken place, although the UN Charter creates a mechanism for automatically this review being placed on the agenda of the General Assembly and a conference to be called only by a simple majority of the General Assembly and any 7 members, not even 9, any 7 members of the UN Security Council. And it is time, therefore, that such a review be called for, a conference take place. Of course, this doesn't mean that any amendment would be automatic, because that still would require the consent of the permanent 5 members. But the process of discussing the review, having a review, discussing the provisions, the roadblocks, the structure of the Security Council, and having an open conference on this topic has never happened. And that is definitely something that needs to take place at this point. Now, this brings me to very briefly presenting the Department of International Law to those of you who are joining us and wish to join the program. Now, the University for Peace is not a typical law school, right? As you have seen from the presentations given by Dr. Juan Carlos, Dr. Maria Teresa Garrido, and myself. It's not a typical law school where we are looking only at how international law is. We are also looking at critiquing international law where it does or does not work. We are looking at how international law ought to be. We are looking also at reforming international law through international law itself. And all of this is because the University for Peace is a peace school. It's fundamentally a peace school, which means that the study of international law at UPEACE is not just an end in itself. You're not studying international law just for the sake of understanding what it is. In fact, the study of international law at UPEACE is a means to an end, and that end being peace building, fundamentally because we are a peace school. And therefore, at UPEACE, what we are studying is how international law can be an instrument, can play an instrumental role in peace building. We reject international law as a tool for neocolonialism in our studies, in our discussions. We also reject the selective application or use of international law, as I've pointed out, for instance, the selective outrage against Russian invasion, while ignoring similar actions by the West. Now, there are two master's degrees that we offer. These are the regular master's degrees at UPEACE. One is International Law and Human Rights. The other is International Law and the Settlement of Disputes. Both programs are fully accredited, as all other programs at UPEACE are, by virtue of the United Nations General Assembly Resolution 3555, which approved the establishment of the university, and the General Assembly resolution has an annex to it, which is the international treaty that establishes the UPEACE, along with its charter. And these provisions confer upon the university the mandate, the international mandate, to award master's degrees and doctorate degrees. And so if you actually go to the UNESCO's website, you will see that the accreditation of UPEACE and its degrees is referred to as granted by the United Nations, which is very different from any university. As you know, the UN is the one that accredits the UPEACE degrees. And I don't have a slide showing you the actual diploma that students receive, but the diploma actually says that by virtue of the authority granted by the United Nations General Assembly, Charlotte Killian is conferred with the degree of master's degree of international law and human rights by the University for Peace. So the value of the degrees is tremendous. I should also point out that in addition to the accreditation by the United Nations, both programs are also accredited by the National Higher Accreditation Body of Costa Rica, which is also called as SINAIS. Now, this is a truly international experience, as students from UPEACE who are joining will testify. Students come from all parts of the world, not just at the university, but also in the department. At present, for instance, there are 20 students in the department from 15 countries. And, you know, we tend to overlook these facts, but this diversity is absolutely staggering. You know, universities such as Harvard and Yale also have a lot of students from different countries. But what differentiates UPEACE is the sheer density of the diversity of students. It's very dense. Among 20 students, 15 countries is a lot. And this is the type of experience students get. They learn from each other. There's a lot of peer-to-peer learning simply because of this diversity. There's an international faculty in the department that includes academics, diplomats, senior staff of the United Nations, lawyers and judges of international and regional courts. In fact, one of our adjunct faculty is currently also a judge of the International Criminal Court that's looking at the case that we have discussed. And he comes and teaches a course. We have diplomats, we have senior staff of United Nations, and lawyers of international and regional courts also train in the program. Apart from this, students also receive specialized certificates of training from the UNHCR and the ICRC on international refugee law and on international law, humanitarian law. These are certificates that are granted by these institutions in partnership with UPEACE. So that is one of the unique selling points, the USP of these programs, and that definitely helps students to build up their CVs. In terms of the final graduation project tracks, all master's degrees, including the law programs, adopt a flexible approach. We permit students to either choose a thesis track or an internship track or a capstone project track, depending on what their entry profiles are, what their career aspirations are, and which track is likely to benefit them the most. And all of this basically means that combined with the entry profile of the students and the program that they undergo, the experience that they get, they end up with an excellent student exit profile, which are ready for international jobs in in international law. So I think I'll stop there with my presentation, and I would invite all of you to, those who are joining us and those who are watching this webinar and have not yet been part of our programs, to consider applying to these programs. They will be a life-changing experience, as our students will testify. And I think this is a good segue to hand over the mic to Charlotte. Charlotte, please go ahead.
Thank you, Mihir. Thank you for your presentation on the UN Charter, some clarification, and also on the 2 master programs. I'll now share with you a little bit my own experience as a student of the Master of International Law and Human Rights. And for this, I'm just giving you a little bit of my background to explain why I decided to come to UPEACE. So I am 27 years old. I'm French. I did most of my studies in France. I did law school in the cities of Strasbourg and Toulouse, and I also did 2 exchange years in Italy and Norway. After this, I got an internship at the ILO, the International Labour Organization, which is also a UN agency in Geneva. I worked there almost 2 years after my internship on labor law, of course, and also on gender topics such as equal pay or work violence and harassment in the workplace. I sometimes felt frustrated because I came from a very strict and narrow perspective from my law school in France. So I was not familiar with human rights knowledge from international law, from the functioning of the UN. That was very new to me. And I sometimes felt I lacked knowledge. I was also frustrated because part of my team worked in Spanish on Spanish cases, and I was not able to help because at that time I did not speak the language. So that's why I choose to come to UPEACE for the theory, because I could have international human rights, but also knowledge on the UN functioning. And I'm really happy of all the topics we covered this year. And also by the fact that, as Mihir said, all professors have very different background. We have UN experts, lawyer, diplomats, people from the academia. So they all have a very practical perspective on this. And they also have a good network that can always be helpful. And of course, Costa Rica is a Spanish-speaking country, so it was for me the opportunity to learn the language. UPEACE is also providing housing solutions, so I had the chance to live in a family for a year. I learned a lot about the culture from here and Latin America in general. Apart from this, and if I compare to my previous studies, I found that the university offers a lot of opportunities. Of course, it's up to each student to take them or not, but as an example, during the first semester here, I could be a teacher assistant, and during this semester, the second one, I could help on the organization of the Model United Nations, that is organized by the university. As our professor just said, the master also offers a lot of flexibility regarding the final project. I decided to do a thesis as I want to prepare an exam, the bar exam in France in September. So they're also very flexible regarding the deadline. So I'm able to prepare myself for my exam and only give my master thesis after this in December. So that really allows me to continue also my career path. And there is also a lot of flexibility regarding the subjects you want to study. I came here also knowing that I was interested in gender studies, and I was allowed to exchange 2 of my subjects in international law with subject of the gender master in our UPEACE. So that was also very complete for me. Of course, if you have seen the website of the university, you know that the campus is located on a very protected area in the middle of nature. So those are also amazing conditions for us to study here, especially after being inside so many months with COVID. And professor also talked about this, but for me, it was also very new to have a global South perspective. As our teacher coming from everywhere in the world, and I did all my studies in Europe, I had a very Western centralized perspective. So now I have a widened perspective and more critical also on what I studied before, like criticism on international law as a neo-colonialist tool, for example. This was very new to me. And of course, the university is super multicultural, so you'll meet people from all over the world. You will learn a lot from this. And Costa Rica is also an amazing country to visit. We have beautiful places. You can also visit country of the region. So as professor said, it was a very nice year and life-changing experience. So I'm really happy that I came here. I know it was totally worth it, even if I had to stop working to start to study again, but I know it will bring me a lot of opportunities for the future. And I also remember that before applying here, I was kind of afraid that it was a UN mandated university. I was like, okay, maybe it's too prestigious. Maybe I don't have the profile. But I think if you're interested, you should really give a try to apply. People have very different backgrounds. We also have people that do not have a low background in or master. So you should not be afraid to give it a try. And I think I'm done for now. We can now open the Q&A session to terminate this webinar. I will just have a quick look in the chat. Okay, so we have many questions for Shaknoza. Thank you for your interest. I'll maybe start with the question from Sita that asks, would you like to comment on Russia's cyber activities to undermine Western and Southern states and societies from the viewpoint of international law and maybe on a positive future cyber war? Are there been any reaction to the Russian cyber activities within the UN system? I don't know who wants to take the question, maybe, I guess.
Maria Teresa, do you want to address it?
Yes, I'm sorry, I have a background noise around here, all of the cars. But yeah, let me read the question on cyber activities. I think this is a very interesting moment in terms of the use of ICTs and these technologies, because we have seen the creation of fake news, we have seen the creation of disinformation, and now we're seeing how Russians are attacking different systems to hack the functioning of the state. There aren't like real regulations on these topics. That we don't have like a clear point of view, because as you know, this is something very new, but we do have certain reactions from different states. Sorry, I muted myself for a minute. There are different reactions from different scholars, and we can see what the private sector has been doing. So we have seen an increase on security systems and the alliances between states and other bodies to actually impede the hacking of the system and the consequences of those hackings. And I think this is a field in which we will see a lot of development in terms of cybersecurity and cyber war, because as you know, this is one of the first times in the history of humanity where we have this hyper-connected system in which the governments are relying to have different opportunities to solve the conflict. So I think that's a good entry point for international law, international humanitarian law, and this technology and law.
Thank you, Maria Teresa, for this precision. I'll now take another question, maybe the last one from Shaknoza. I guess it's for me here. Shaknoza asked, if the Article 109 spells out such provision for reviewing the UN Charter, why has it not been yet activated?
There were attempts made in the 1960s to activate it, but unsurprisingly, the attempts were blocked or rejected by the Russian Federation. They opposed it along with some of the countries that were aligned with the with USSR actually at that time, based on the Cold War alliances. So the simple answer to that is that there was no political capital, there was no political will at the time for a review to take place, and because of passage of time, the provision simply went out of the minds of everyone. And I think it is the right time. Therefore, I'm saying it's the right time now to activate Article 109, and it's not a difficult thing to get a simple majority at the United Nations General Assembly and 7 members of the Security Council. Of course, that's quite a different thing than saying that a review takes place and what comes out of that review, those are two different things, because what comes out of that review also needs to satisfy the foreign policy interests of France, United States, and United Kingdom. It's not going to be just Russia and China, so all permanent 5 members have to have their interests satisfied. And therefore, we come back to the main issue, the main problem of the United Nations Charter, which is the original birth defect, that the victors of war created a system that conferred upon themselves such tremendous powers, and also introduced a rule that any modification in those provisions would require their consent. Right. So this is where the United Nations system is stuck. However, a review process, the process itself, will be very valuable to have, because that's not been done. At least the positions will be openly discussed. Everyone would know which country's position is what. Civil society pressure can be built up, and all of that is absent in the without such a review process. So that's the answer, that there has been no political will, but I think there is enough now for that to start taking place.
Thank you, Professor Kanad, for this very complete answer as well. I'll now take the question from Katia. So might be for me here as well. In your opinion, how are the Russian human rights affected by the sanctions? And she has a follow-up question. Do you think we have sufficient elements for the ICJ to define the situation as a genocide? And how can gender-based violence be considered in this answer?
Yeah, I'll answer the first question, and then probably Juan Carlos or Maria Teresa can take up the second question relating to whether there are enough elements to consider the Ukrainian action as a genocide. I can just say that I don't think there are enough evidence at all for the Ukrainian action in Donetsk and Luhansk to be branded as a genocide. But I'll leave it to Juan Carlos and Maria Teresa to take it forward. On the other hand, I don't know if your question referred to whether the Russian action amounts to a genocide. No, I'm not too sure it amounts to a genocide, but war crimes for sure. And there are enough elements there before the International Criminal Court to consider the Russian action as violation of international humanitarian law. Now, on the first question, which relates to how are the Russian human rights affected by the sanctions, this is a topic that has been hotly debated at the United Nations level, not just in the context of Russia, but also in the context of Venezuela, Cuba, Myanmar, North Korea, and Iran. The special rapporteur on unilateral coercive measures, who incidentally is from Belarus and is in a very tough position right now because of the stance she has taken, has produced a lot of reports on the human rights impacts of generalized sanctions imposed by third countries on the citizens of a country. So if you look at the sanctions on Venezuela, these are generalized sanctions. And what she's pointed out that the elites hardly suffer. It's the common person on the street that's suffering because of these sanctions. If you look at the situation in Venezuela, both Maria Teresa and Juan Carlos might be able to testify to this, that people are literally bartering things. The economy has collapsed. They're bartering, and they were bartering for a long time, a diaper for a bag of rice and things like that, right? So it's the common person on the street that suffers. The intention behind generalized violence, generalized sanctions, is that there will be a regime change. People will revolt against the government. But history has taught us that it doesn't work that way. People don't revolt against the government to the effect of effectuating a regime change. There's something really rotten about the idea of making lives miserable of people in a country with the hope that they will change the government by a rebellion. Particularly in the context of the COVID-19 pandemic, whenever such sanctions are taking place, people in the country in general have limited access to vaccines. Imports are banned with relation to medicines and therapeutics. Trade is restricted. So in general, the reliance on what is, the benefits of trade, the benefits of interconnectivity are prohibited. So there's enough evidence to demonstrate that generalized sanctions hardly ever make any difference. Kim Jong-un is not suffering. It's the common North Koreans on the street that are suffering. He's living a lavish life. Same is the case with Iran. The leaders hardly suffer. It's the common person that suffers. And it's going to be the same in the context of Russia. Whatever evidence is coming out, majority of Russian citizens are against the war. In fact, majority of the oligarchs are also against the war. All these generalized sanctions are going to have a tremendous adverse impact on their human rights. And therefore, I have always been against, as some of you know, against the idea of generalized or blanket sanctions. However, targeted sanctions are what are also called as smart sanctions, meaning targeting the individuals that are responsible for certain decisions, like Vladimir Putin and people in the Kremlin. Those are legitimate and legal under international law as long as they are proportionate and as long as they are necessary. So that's where I can give my comments on the points about the question on sanctions.
Yes, I would like to jump on the particular question about the genocide. Remember that the case was open because Russia used the argument that Ukraine was committing genocide on the Donbas region. Was the legitimization of Russia. And of course, Ukrainian government took, okay, you said that I'm committing genocide. Okay, I will take it to the court. I mean, it's completely the opposite, okay? So, and I think in a law program, we need to analyze the procedural element. It was extremely wise from Ukrainian to use the statement of Russia saying that they were the one committing and immediately presented it into the ICJ and opened the door, because normally ICJ does not respond so quickly in a conflict. They prefer to go behind and to analyze later on the application of the international humanitarian law. But in this case, the Ukrainian legal team took the opportunity and immediately introduced. And it's extremely important also to highlight that some of the lawyers that traditionally has support Russia, for example, Professor Alain Pelé and other important lawyers, resigned from the Russian team as a result of the invasion, because so is something to analyze. So of course we can go about all the elements, etc., but I think what is relevant for us is the use from the Ukrainian point of view of the ICJ in a legal strategy. In relation with the gender-based violence in this answer is something that, you know, as I said before, this is more on a political side. They are using this element because Russia used it, okay? And I think Mihir also briefly mentioned the issue that, you know, in this context, in genocide, this gender-based violence is not on the papers. We have seen some of the elements with the gender perspective, and that's why it is very important the Commission of Inquiry from the United Nations High Commission of Human Rights, and also the Eurojustice, that they decide to open up the mandate of the Eurojustice to collect evidence, to send it to the ICC, that at the end will be the International Criminal Court, the one who will handle these elements of gender-based crimes that I think they are working very hard on that. I think in the case of the ICJ, they will concentrate more in the more political argument. That would be my answer. Thank you.
If I can jump in, because as Juan Carlos was saying, this is an open investigation. So it means that they will gather all of the information, and coming back to the idea of the use of social media and all of these technologies that we're seeing, we already have a background in the case of Mahmoud Mustafa in Libya about using social media and all of these posts to actually conduct investigation and issue warrant of arrest. So I think this is another interesting way of observing how the ICJ is is going to actually conduct the investigation, that it is the moment to do that, to actually prove if there is a genocide or not, and what are the arguments and what are the base. So we can take a close look to what the ICJ will be doing in the terms of collecting all of this information that has been posted on social media to actually determine if they will open the case or not.
Thank you. Thank you to you three for this very complete answer. I now have a question from Napoleon that asks, the reaction times of international law continue to represent a challenge for the containment of hostile actions, such as those of Russia against Ukraine. However, how could international norms be updated to be proactive and not reactive in conflict resolution? I don't know who wants to take the floor to answer this one.
Yes, I mean, I think that the question from Napoleon is it is not just in international law. I think it has to be with law. How law can detain the use of force. Can the use of force detain domestic violence? I mean, you know, if you have a problem within a house, I mean, it's very difficult. So we're not talking here about the role of international law, it's the role of law. And that's why the University for Peace stands for the idea that war starts on the mind of people. So we need to educate people in order to avoid conflict. Law is something that comes later on. So I think that you know, it's a very important question that Napoleon Martinez asked, but is more complex. It's more philosophical context, because we're talking about violence and, you know, transnational, national, and domestic. And I think that's why we stand for the idea of education as the answer, not law, because law, punishment, what we saw in something like that is escalation of the use of force, and the escalation goes more and more conflict, and that will never end. That would be my response. I don't know if my colleagues would like to add something else.
I'll just add this, that, you know, the ideal situation, of course, is that international law should be more proactive than reactive. It's also true that international law and the United Nations system has always played catch up with the changing realities of conflicts as they have happened. For instance, when the United Nations system was established, it was established for interstate conflicts. I mean, intrastate conflicts were not in the minds at all. And that's the entire reason of the structure of the United Nations, right? So if you look at the Security Council's mandate, it is for resolving, maintaining international peace and security, right? However, as the Cold War ended and more internal armed conflicts started with the genocides in Srebrenica or Rwanda or elsewhere, now, the United Nations Charter had to be reinterpreted to accommodate interventions by the Security Council, not just in international conflicts, but also internal armed conflicts. The responsibility to protect doctrine that I alluded to also came much later in 2005 as a response to precisely this problem. What do we do if there is a genocide taking place inside a country? Is the United Nations Security Council or the United Nations in general prohibited from taking any measures? Would that amount to intervention in the domestic affairs of a particular country? And hence we had the responsibility to protect doctrine, which said that, look, if a country is manifestly failing in protecting its own population from genocide, war crimes, ethnic cleansing, etc., then it is the role of the international community to step in. It is their responsibility to step in. So sovereignty is not a privilege. Sovereignty is a responsibility of a state. And if it's not discharging that, then the international community must step in. So international law does play catch up in that. Now, why does international law play catch up? The answer is, again, straightforward, that the international legal system or international or global governance in general operates in the complete absence of a world government. At the domestic level, we have a domestic government. We have a government, we have a parliament that makes laws, and those are binding on everyone. So the opportunity for a domestic legal system to have proactive laws flows from the idea that there is a government. global governance operates in the complete absence of a global world government. There is no world government. The Secretary General is not the world president. The General Assembly is not the world's parliament. So there is nothing in international law which confers upon a particular body the role or the authority to make laws that are automatically binding on others, which means that international law operates in a decentralized system of nation states where every state must consent to be bound by a particular law. If it doesn't consent to be bound by it, then there is simply no, then it's not bound by it, right? And which basically means that that the domestic and foreign policy interests of states play a key role on what they will agree to and what they will not agree to, right? So it's very straightforward to say from an ideal perspective that, look, the Security Council suffers from a birth defect. The UN Charter's international legal system of peace and security could be strengthened, could be bettered. We need to reform it. But international law itself confers the Security Council the primary mandate and also confers these permanent 5 members the veto powers, right? And it is unlikely, because of this decentralized nation-state system and because of the idea that everyone must consent, it is unlikely that permanent 5 members are going to consent to reduction of any of the lopsided powers that they enjoy under the system. And so international law operates in this context, and it has to live with this context till such time that we are in the future Star Wars kind of era where we have, this, a centralized system where decisions are made and they become binding on everyone, whether you agree or not. Who knows, we might move to that circumstance in the future, because humanity doesn't learn anything unless there is a catastrophe.
Thank you, Professor. We have 3 questions left from Shaknoza, so I'll try to ask them one by one, and if you can give a brief answer. So the first one is, what are the practical implications of exclusion of Russia from the United Nations Human Rights Council? Other than the strong message, how does it help to end the war?
I mean, I thought that you will summarize the 3, Charlotte, or one by one. I mean, we can go one by one.
Okay, I can read the 2 others, so you know.
I mean, let's solve this one. Okay. Clearly, Januza, as I respond to the previous one, when the war starts, it is the role of international law is extremely limited. Because when a war starts, the only thing that can stop a conflict is politics or the use of force. And if we use of force, what we have is an escalation of the conflict, and it's not what we want. Okay, so that's one. What represents this decision to suspend Russia is the consensus of the international community that what Russia is doing is not legal, is not correct. And this consensus is extremely important in order to construct a collective response to what's going on right now, and the collective response that is what's going to happen in the near future. Because the conflict would end sooner than later, it would end, and we need to reconstruct Ukraine, but also determine responsibilities. We need to punish the crimes that happens, and we need the consensus of the international community for this phase of what is going to happen. And in that sense, I think we need to read it in that line. That will be, Charlotte, my response.
Thank you so much, Professor. I'll give the last 2 questions from Shaknoza. I'll try to summarize them. So the first one is, why did Russia even attempt to bring the matter to the Security Council in the first place for protecting the ethnic Russian in Donbass? Even if it would have never approved, why they didn't perform the formal step? And the second question refers to the member of USSR. So Russia is an official successor of USSR, Ukraine not. And she asks, so Ukraine was present as a separate member state of the UN even before the collapse of the USSR, in contrary to other parts of USSR. Do I read that Ukraine also had the full right to take it over from USSR Could this fact be used for reconsidering the legitimacy of Russia inherits the USSR membership in the Security Council?
I can respond the very first part. As I said, Shagnoza, the aggression was brought into the Security Council by the United States, not by Russia. What happened is that Russia was exercising the presidency of the Security Council. And what is relevant for the international law is that even though Russia was heading the Security Council, they accept to discuss. They block it because they use the veto later on. But what is relevant here is that they knew that what we're doing was not legal, but even though they follow all the charter in the sense to accept to convene the meeting, to call for the meeting and to discuss that. But it was not Russia, it was the United States, the one who brought the topic to the Security Council. That would be my response. Thank you.
Thank you, Professor. Anyone want to take over?
I'll just jump in on both questions very briefly. Russia, prior to the conflict, of course, since 2014, Russia did not make a serious attempt to itself bring the matter to the Security Council for protecting the ethnic Russians in Donbass. It did not make a serious attempt. It did, however, at all possible occasions, bring it up whenever human rights situation of Ukraine was taken up in other forums, particularly Human Rights Council or the Universal Periodic Review. It did bring it up. There was enough evidence, right? There's enough evidence for the fact that the ethnic Russians in Donbass, many of them were indeed targeted. Let's not lose sight of that fact. That they were targeted by the armed forces. There were violations of their rights that were taking place, but none of that ever justifies the disproportionate use of force that Russia made. Even if that was the case, then every country would be within their rights to invade another country, say because there are human rights violations. The human rights violations in every country in the world. That doesn't necessarily entail the legitimate right to invade that particular country. So Russia did make attempts, but of course, nothing that could be called as a serious attempt with the objective of invoking the Security Council's mandate. The Russian Federation, under the present President Putin, is often known for doing their own way, the way they want things to happen, ignoring the law. Juan Carlos and I were recently in a meeting with a colleague from UNITAR who shared with us this instance where the Secretary General of the United Nations in New York decided to impose a rule that the whole United Nations premises would be nicotine free, so there would be no cigarettes within the United Nations headquarters permitted. Lavrov, who is the foreign minister, as you know, of Russia, is a smoker, and he asked the Secretariat to show him the rule that conferred the Secretary General with this power to make rules on how the United Nations headquarters should be run. And he said that it's not the Secretary General that makes the rules, it's states make that rule, and therefore I'm going to continue smoking. Right, so you can see that if they have their own way of dealing with matters such as this. I don't think they necessarily care so much internally, although they would like to show make a show that they that they're justifying the actions with relation to international law. On the second question, that is a very interesting one. I think within the law department, we have had this discussion on a WhatsApp chat with the students. There is something there. There is something there in terms of the legitimacy of Russian Federation being the official successor of the USSR. There are questions that need to be asked there on what process it was followed, because in case of China, remember that after World War II, it was the Republic of China that is a member of the Security Council, a permanent member, and a member of the UN. Not People's Republic of China. And Republic of China referred to what today is Taiwan. right? So in the 1970s, however, there was a resolution adopted by the General Assembly that changed the membership from Republic of China to People's Republic of China. But nothing like that happened in the case of Russia and USSR. So there was no resolution. That's why even today, if you look at the UN Charter, the current version of the UN Charter also says USSR is a member of the United Nations and a member of the Permanent Five, not Russian Federation. However, so there is that legal argument that can be brought in, and the Ukraine's, I think the foreign minister also did bring that up before the Security Council at one point. And then there are counter arguments, the counter arguments being that the law of state succession meant that Russian Federation inherited all the rights and obligations, all the privileges and liabilities of the Soviet Union as a result of the agreements, internal agreements within the post-Soviet countries, including Ukraine. And a stronger argument is that none of them ever objected at that time. So there's a doctrine in international law called acquiescence, which means that they waived their objections. They acquiesced in the fact that Russian Federation is a rightful successor of USSR before the Security Council by never objecting to it from the beginning and continuously thereafter. So there are arguments on both sides regarding this. I can tell you that if there is enough political will, it is not impossible for the United Nations to actually expel Russia from the Security Council. It is legally possible, provided there is adequate political will. The larger question, of course, is what good will that do, right? If Russia is out of the system, then it's not bound by any of the obligations of the United Nations system. It would literally be entirely unhinged. There would be nothing that constrains Russian Federation anymore. Yes, they won't have rights, but they also won't have obligations that the United Nations system requires to be conferred on all its members. So that's a good question, and there are arguments on both sides. As I pointed out, if it depends on who's paying you as a lawyer, right? You could argue on both sides.
Thank you. Thank you. We have answered every question. I thank you all for joining the event, and I'll give the floor back to Professor Kanad to some final remarks.
Yes, thank you very much to all of you for joining the webinar. The recording will also be made available on our social media platforms, so those who could not join us. And I'm speaking now to not just the participants who are part of the program and who have joined us, but also those who are aspiring applicants who want to join the international law program. As I've pointed out, as Charlotte pointed out, as my other colleagues have pointed out, UPEACE does not look at international law just for the sake of it. It's not just it's not just something that we study because it exists. International law plays an instrumental role in our perspective, and it must always contribute to peace building. So if your objective is to see a better world, contribute to a more sustainable and peaceful world, and if you want to explore and become a practitioner of international law in that process, do consider joining the international law program, apply for it, and at least also spread the word to those who intend to work in international law as a field towards peace building. So thank you very much again for joining.
Thank you everyone again. And I think we have reached the time limit. So I'll let you go back to your occupation and I'll end this webinar. Thanks again to all the participants.